welcome back to Winning Isn't Easy. We're going to talk about disability strategies and the value of the case. And to get started, the obvious question is, well, how does a person whose claim was denied or terminated go about finding the right attorney for them to represent them in this appeal process and ultimately potentially litigation? So, Kate, what are your thoughts?
Well, I guess the antecedent question I might start with is, you do need an attorney, and you should get one. Sometimes the insurance companies actually sort of direct people to doing it themselves, saying things like, well, you don't need an attorney, that could be expensive. And they send like a little form, and you just fill out this form for your appeal. That's sufficient. That's actually really, really misrepresenting the whole appeal process and the importance of the appeal. So number one, don't listen to the insurance company saying, oh, this is nothing, just send in your appeal and here's a form you can fill out. That is actually incorrect information. So you need an attorney. So the second question is, where do you find one? Well, of course, online, resources are good, certainly talking to other lawyers, but what you want to look for and what sort of distinguishes the lawyers that do this from anybody else is the funny word ERISA. ERISA, which one judge down in your neck of the woods once said means everything ridiculous invented since Adam, which
Right.
shows you how he felt about ERISA. But ERISA actually stands for the Employee Retirement Income Security Act of 1974. And that's a lot of language to simply mean the federal law that governs employee benefits. When you're looking for counsel, you're going to want to look for lawyers that do ERISA. If you just look for folks who do disability, you might be falling into getting people that are personal injury lawyers or people that do workers' compensation, state law workers' compensation, or even Social Security disability. And those are very, very different kettles of fish, if you will. What you want is a lawyer that does ERISA. So you want to look for somebody who has expertise in ERISA. And then the last piece of advice is, well, how do you select? Let's say you found several people that do ERISA. What are you looking for? Well, you want, probably most importantly, someone you get along with. You're going to be entering into a very difficult situation on an appeal, and then in the subsequent case in court, if that goes that far. And you want someone you can trust and feel comfortable with, and comfortable discussing complicated, usually medical questions with, and have that feeling that this person empathizes and understands and listens. That'd be the first thing. Second thing is, you want to take a look at your plan or your policy to make sure there's nothing in there that requires the case to be brought in a particular jurisdiction. There are sometimes clauses that are in policies that say you can only bring a lawsuit about this in XYZ state. If it may be the case that XYZ state, for example, is where your employer's home office is. If you've got a really big, large employer, you might want to look for a lawyer who does ERISA in that state if you have one of those kind of provisions in your policy. Because otherwise, what's going to happen is you might get started with a local ERISA attorney. Not that it's impossible, you could certainly switch. But if you're going to establish the rapport and the knowledge with one lawyer, it's nice if it can be the same lawyer all the way through the case.
Great. When you are talking to a client about ultimately what their case is worth, because that's always a question that I get. What is my case worth? How long am I going to get benefits? What's this whole process about? How do you explain how an ERISA disability case is valued and what impact the standard of review or even the judge can have on the value of a case?
Well, usually my practice was to speak with the client first, what the just basic on paper value of the case was. And that depends on the facts. If the person has a disability that is unlikely to get better, and they're looking at a situation that's going to last for the rest of their work life through age 65, 67 usually, well, that's one thing. Now, if you have a person with a disability that's going to take a year or two, and then the person is likely to be able to return to work. That's a different kind of evaluation. But in either case, we take the benefit percentage that's in the policy, very customarily 60%, sometimes 65%, but that's most common. It'll be in your policy. You just look, it'll tell you what your percentage of benefit is. And it's usually that percentage times your monthly compensation. Now, it gets really complicated, of course, if you're somebody who makes a lot of money and has a lot of different forms of compensation that we typically see in like senior executives that have very, very complicated compensation packages. And there it's really kind of hard to say just over the how that is done. But then you would take a very, very careful look at the elements of the compensation package and the policy to see what elements are actually covered. Because you don't, just because as a senior executive you have this fabulous whatever that's paying you all this extra supplementary compensation in addition to your regular wages, it may or may not be a covered compensation. So it might not be used to calculate benefits. So we'd have that kind of conversation, and then we sort of multiply it by the period of time that we think disability is going to last. Then you also asked about the standard of review. When I talk about the standard of review, I'm really talking about what is the chance that we will win in litigation. If this is just at the administrative appeal phase and somebody asks me that question, I'm going to say, it says we just do the very, very best job we have and do the best job of creating the evidence we need to support your claim. And, assuming that I think, we've got evidence that should be sufficient 60 or 70% of the time, or even, more than that, I'd sort of multiply that by the percent of benefits, but understand, and this is really important for clients to understand, sometimes they say, oh, you mean I'm going to win this times all the years that I could potentially be disabled?
Right.
And the answer is no, you will not. The claims people are only going to pay a month at a time going forward into the future. So being cognizant of how much potential claim there is over time versus what will be the actual benefit at the point we get the appeal reversed is a very important thing to explain to people, because the claim to date, or the amount that is accumulated at the time that the insurance company goes, "Oi, we were wrong, we're going to pay your claim," they're going to pay the back claim and bring you current. But that's all they're going to do, and then start paying you monthly so long as you keep going forward. So that's what I try to explain.
Yeah, I absolutely agree. We start out with what are the gross amount of the benefits, but there are several other things that we have to talk about, and that is an offset provision, because most disability policies or plans require the individual to apply for Social Security upon pain of acting as if they were getting it when they're not. And they'll reduce those benefits by not only the receipt of the policyholder's beneficiary benefits, but the beneficiary's children. So if you've got 3 kids and your children are getting Social Security disability benefits on your record, that's going to be used to reduce the value of the case till those kids drop off. The other thing, of course, that you mentioned before was we also have to be concerned about policy limitations for subjective medical conditions or mental nervous conditions. So, you may see online that there are some law firms that have calculators. You can calculate the value of your case. But more often than not, I'm sure we both found that those were inaccurate because they just didn't take into consideration how to calculate the base wages, the offsets, and any policy limitations. I asked you about judges. And, when we get into a situation where we have to file a lawsuit, one of the first things I want to know is who's the defense counsel. And the second thing, or maybe the first thing, I want to know who the judge is. We used to have a judge here in the Tampa district who, in her many years on the bench, I think maybe only awarded a handful of cases found in favor of the claimant. And we knew that and the carrier knew, or the plan knew, that our chances of winning were maybe about 10 or 20%. And so the legal bookie odds, if you will, have been a factor in the value of the case. Could you speak to that at the litigation stage?
Yeah, it's an unfortunate. I mean, it's very unfortunate. It's actually dreadful that particular judges' predilections might have an unmerited influence on how they would decide an ERISA case. It's just wrong. Unfortunately, federal judges are appointed by a federal court, by the federal Congress and the president, and they're in the federal system and they're appointed for life. And there's very little you can do if you get the wrong one of the bad judges, because just knowing that they have a record of ruling against claimants in ERISA cases will not do you any good in terms of seeing if you can get another judge. Having said that, we have to work within the system we've got, and this, flawed though it may be, is the system that we've got. So certainly knowing who the judge is going to affect my evaluation of the case. In Minnesota, I live in a state that a lot of people think of as a blue state, but our bench is actually significantly comprised of judges that were appointed by red presidents. In fact, overwhelmingly so on the Eighth Circuit, which is the above court for this part of the world. And so you do have a problem in that your claimant may be assigned to a judge that just has a doggone different idea about these kinds of claims. And it's going to change your evaluation. And a good lawyer is going to tell the claimant that right up front, so that going forward, the claimant knows, well, I did not win the lottery here, and I need to adjust my expectations accordingly. Doesn't mean, by the way, that every judge is against claimants. By no means. I've received decisions from very conservative judges that are very favorable to my clients. And honestly, I think most federal judges do try to do the right thing. But you may have a judge that's just, for whatever internal calculation that person does, is not as inclined to rule for claimants. And you want to know that, because it may spur you to try and resolve the case by settlement differently than you would otherwise.
Which leads to that next question. And that question is, how and why are ERISA disability cases settled?
Well, yes, right. For sure, cases will be settled when either party knows that the judge that is going to be adjudicating the case is friendly or unfriendly in general towards that particular case. But by the way, when we say friendly or unfriendly, it's just sort of what we can learn from looking at the decisions that the judges reach. No lawyer knows what any particular judge is thinking about their particular case, other than what is said when the court meets with the attorney. So we're trying to make educated guesses about what Judge John Doe might do on any particular case. And if my client did not win the lottery, there's a high degree of likelihood that I may be more interested in trying to settle and might be more willing to take a lower number.
So I have clients who will call me up and say, well, why should I pay you either a flat fee or a percentage of my benefits to handle my case, my appeal? I can do it myself. Any thoughts or comments about that one?
Well, I think we've sort of given a foretaste of that. And that is that the administrative appeal in particular is the single most important thing that's going to happen in the case. And if you want to win your case, that is where you're going to want help to make sure that you have developed all the issues correctly and have developed all the evidence that you're going to need to respond to the insurance company or the plan's objections. And, it may be an equation that some clients look at differently based upon how much is at risk. I've told clients, you don't have a very large benefit. You have a very generous Social Security benefit, and you're going to get that. You might not want to hire me to do your disability claim. In fact, what I do if I were you is focus on that SSDI claim, appeal, because you don't want to miss a deadline, right? bring the appeal of your LTD claim, but by the time that's rolling around, you might have had a decision in your favor on the SSDI claim, and that's going to help your LTD claim. And if it's not a very big amount, why would you want a lawyer? Because the lawyer really, it's not worth it on a small value claim for small value claims. A larger value claim, or one that's going to go on and on and on, you really need a lawyer.
Right. So if you were to give advice to someone who is looking to hire a lawyer, and what would you tell them about how they could help their lawyer write a winning appeal letter? What information they can provide, what insight they can provide? What advice do you give them about how you can help the lawyer do a better job?
So this assumes that the lawyer is actually retaining me to help their client.
Right.
Okay. Well, I mean, we do that too. Sometimes we talk about it being kind of like ghostwriting the appeal, and with in consultation with the lawyer who's already been representing, we talk with that lawyer. We go through the legal analysis, the factual analysis. We will outline the appeal maybe, or talk through the appeal so that the other lawyer can write it up with our overarching guidance. But most often what happens is we do the writing of the appeal, and the retaining lawyer looks at it and goes, wow, I wouldn't have thought of that. Thank you.
We'll refer all the other cases to you thereafter. Right?
Yeah, that happens sometimes. Yeah.
So one of the things that I absolutely insist on is that if I'm going to represent the client in the long-term disability case, I'm going to represent them in the Social Security case, because I want to control both. But if that's not the situation, I always say to my clients, well, one of the ways that you can help me help you is get me your Social Security file from your lawyer, or give me their name so I can contact them. And by the way, in the Social Security case, your lawyer should be using some forms called residual functional capacity forms, which are highly enhanced attending physician statement forms you have to get. So if your lawyer has gotten them, I want them. And if they don't, have them call me, and I'm going to give them attending physician statement forms that they can use to help both cases. The other thing I will do, and I'm sure you've done, is to ask, well, who in your family or friends or at your employer's place of business could give us a statement to address whatever the issues are. Are there any thoughts about any other things that you have told your clients in the course of your practice that they could do to help you with that ERISA disability claim?
Well, mostly what I want to do is talk to them. And I like to talk to them multiple times, because it's interesting. We're humans. We don't always know what's important when we have a conversation with somebody, even if it's about something very important like your benefit claim. I've had cases where I was preparing the final drafts of the appeal submission, and the client just mentioned something off the cuff, and I'm like, that's a very important piece of information. I needed that, yesterday, but let's work with it now. So I would tell people not to be surprised if they have multiple conversations with the lawyer, or at least the paraprofessional working closely with the lawyer and preparing your appeal. You should expect to talk to them a lot. And if you're not talking to them a lot, chances are they're not getting the information they need.
No.
But in terms, sorry, go ahead.
One of the things I've always suggested to them is, look at that denial letter and tell me what you think is wrong with it.
Yep.
Because again, a lot of sites will come from.
A lot of times the clients never have actually read the denial letter. They've got to the bottom line first and said, benefits denied, and they don't read it. And so obviously that's important, because that's what the reasons were that the insurance company came up with for why they were going to deny the claim. I think the other thing is to think creatively. And I want to talk about a friend of mine had a case where he was prosecuting a claim or bringing an appeal to get benefits reinstated for someone who had multiple sclerosis, which can affect cognition and cognitive capacity. And they had collected tons of records from the neurologists and the primary care doctors and all the usual people you would think about. And the client was also seeing a psychiatrist, and this is not unusual for clients to not mention their mental health care providers. I want to know about that too. But she mentioned that she had seen the psychiatrist and they had been doing a Rorschach ink blot tests or something like that. He requested copy, or maybe it was drawings that the client did. Forgive me, there were drawings the client did of her feelings. And these were shocking pictures. They sent those in and the appeal was granted.
Wow.
Another time I had a client who was a young girl. Her parents were actually my clients. It was a medical benefits case, but the same basic principles. And she was being treated for severe bulimia and severe harming behaviors. And in her treatment facility, they had all of the patients do full-sized body drawings of their body and their self-image. It was very disturbing. I submitted that. So thinking creatively, I have had, of course, the usual things, videos and audios of interviews with my client. That kind of goes without saying in many cases. But thinking creatively about what is the one piece of evidence or one explanation that you give to somebody about why you're disabled that just sums it all up? It's not just the elevator speech, and it's important that it not just be my diagnosis is ... It's when the person says, I am a surgeon, orthopedic surgeon, and my problem is I have Dupuytren's contracture, which is a very annoying, difficult situation where the fingers stop contracting, so they get sort of stuck. And it's worsened by cold. And, when you are doing an orthopedic surgery, you are in a very cold environment. We keep operating rooms very cold. We keep our materials cold. We have ice there to apply to the patient and to chill things down. So my hands are cold the entire time, which only makes the Dupuytren's contracture worse. And guess what? Sometimes I only have 2 fingers left to stitch someone up. And, that just saying Dupuytren's contracture, what's the big deal? See it on TV. There's medicine for that. Not necessarily, and not if you're an orthopedic surgeon. So it's having a sensitive conversation and thinking creatively about how would you explain to somebody why this is really a problem? And it's usually something that's very, very graphic. I couldn't get on the elevator because it went too fast because I have to walk very, very slowly and my arm got caught. Something like that. Usually these simple anecdotes are some of the most powerful pieces of evidence you can submit.
Wow. Fantastic tips there. So we're going to take a break before we do our last segment. So we will be back getting some final thoughts and insights from Kate before she moves into her next stage of life. So let's take a quick break.